I believe in recording in progress. I believe in rewarding good behavior and rewarding being here on time. And so I appreciate everybody showing up here early and being with me. I see somebody's got their hand raised. Hi, good to see you as well. I do see a question already coming in. Lots of echo with the audio. How do we correct this? And I see it looks to me like you've joined twice. And I don't know if you are seeing that. I don't know if you have a couple of windows open, but if you have a couple of windows open, my guess is that you might be experiencing that echo from there. It looks like now you're just down to one. I just see you once in the attendee list. So hopefully the audio is better. Let me know if it is, and if that was able to fix it. I get a lot of questions about the kind of the logistics behind this presentation. Yeah, it looks like just corrected. Perfect. That's good to hear. So I get a lot of questions about the logistics of this presentation. One of the questions that I get is this being recorded? And the answer to that is yes, I am recording this, and I will share that recording out to YouTube after this, and then go ahead and email the recording to everybody who's in attendance, as well as to the people who were not able to attend tonight but expressed an interest in attending as well. Another question that I often get is, can I see you? And the answer to that is no, I cannot see you. I can see your name if you are in attendance here as a participant, but I cannot actually see the video through your computer. So rest easy. If you have sweatpants on or whatever, don't worry about it. Come casual. And it's just good to have you here. I'm glad that you're here. I can't see your picture. Another question I often get is, can I hear you? And the answer to that is no. If you have a question that you want to ask out loud, we have the capability of doing that. I can allow you to talk, but otherwise I can't hear what you're saying. And if you're making fun of my haircut or something like that, you know, I can't hear you, so I don't take any offense. But even if I was able to hear you, I wouldn't take offense. It's not a big deal to me. I did have some questions coming in, and the way that those questions were coming in is through the Q&A button, and you should see that somewhere on your screen. There's a Q&A button where you can ask questions. There's also a chat button, and as long as you make sure that that chat button is at least going to the presenters, I will be able to see anything that you chat at me. One final question, will this run the full hour? And the answer is yes to that, and I really encourage you to stay. I have some great offers I'm going to make at the end of the presentation, and I want you to be here for them. I want you to see those. Again, it's 7 o'clock now, and I believe in rewarding timeliness. So let's go ahead and get started with our presentation tonight. Hello, everybody. My name is Timothy Scott, or TJ Scott, and I'm an estate planning attorney and the owner of the law office of Timothy J. Scott. I'm so happy to have you here with me today. We're going to be talking about something that I know is a difficult topic. It's difficult to think about things like incapacity, and it's difficult to think about things like death and when we pass and what's going to happen after we pass. But I believe that knowledge is power. And today I really want to empower you and educate you and hopefully give you some peace of mind around this topic and around how you can make sure that you have planned and you've taken care of and you've got your affairs in order for the people that you love. So today I have some really valuable information, and I am going to share some valuable offers towards the end of the presentation. So please stay with me all the way through the presentation so that you can hear those offers. Okay, the best way to learn here today is to be present with me. And I really encourage you to turn off the distractions around you. If you have the TV on as well as the computer here, I encourage you to stop it. The TV will still be there after this presentation is done, I promise. But I really encourage you to give yourself this time that you've set aside to be here tonight. This is hard, like I said. It's hard to start this process. It's hard to get the ball rolling. It's hard to educate yourself and tune into this because I know it's a difficult topic. But I can promise you, your future self is really going to be glad that you took the time to learn this and you took the time to educate yourself about this. You are going to feel peace of mind, but I really need you to tune in and make sure that you are following along with me because there's a ton of information I'm going to be throwing at you tonight. And I know it's a lot to digest, but there's just a ton of information around this topic that you need to have in order to make informed decisions. So I really encourage you to be here with me tonight. And again, if you stick around until the end, I have a couple of offers that I want to make to you. The first is how you can get a free virtual one-to-one meeting with me to talk about the things you have and the people that you love and how you can protect them. Again, that meeting is free. There's no obligation. I just want you to be educated, and I want you to have the information about your specific situation so that you know best how to handle things and how to take care of things. Plus, I have a bonus gift to make it even easier to get a personalized and tailored estate plan in place. And I will be introducing that a little bit later. But first, I'd like to ask some questions of you, if you would be so kind to answer. And the first question that I have for everyone tonight is, do you have an estate plan in place? And a lot of times people don't know exactly what I mean when I say estate plan. They think, do you mean a will? Do you mean something beyond a will? What exactly are you talking about? And really, an estate plan is something that is kind of an overarching term. It's contemplating what happens after you pass away, but it's also thinking about what happens if you become incapacitated before you pass away. What happens if you end up in a coma? What happens if you start suffering from something like Alzheimer's or dementia? What does that look like for the people that you love? And how can you put a plan in place to deal with those situations ahead of time? So in the estate planning toolkit, some things that we use to really create an estate plan are things like a trust, a will, guardianship nominations if you have minor children, or if you have somebody who's reliant on you, dependent on you, even if they're not a minor, a healthcare directive, a power of attorney, and beneficiary designations on your assets as well. These are all tools that we use in order to create an estate plan, in addition to some other tools that I'm going to talk about here in just a little bit. And I am seeing the vast majority of people do not have an estate plan in place. In fact, I haven't seen a single yes yet. I have 11 no's to having an estate plan in place, which is true of a lot of people. In fact, something like 69% of Americans do not have an estate plan in place. And if you don't have an estate plan in place, thank you for sharing in the poll if you did. But if you don't have an estate plan in place, I'm curious, why don't you have an estate plan in place? And maybe one of these reasons here on the screen resonates with you. Maybe you're too busy, and I get it. I mean, life is really busy these days. I can tell you, as a father of four, we recently had our fourth child, and I can tell you I completely understand what it's like to be too busy and to be run thin. But if that's the case for you, I really want to commend you for being here tonight, for taking time out of your busy schedule to explore this topic and learn and educate yourself about this topic so that you can take a good step in getting an estate plan done. And maybe you feel like you're too young. And again, I understand that. A lot of people feel like this is something that they can do when they're older, when they're retired, when they are beyond retired, when they're 80 or something, or 90, even later than that. A lot of people put this off because they feel like they're too young. There's not a great risk of anything happening to them. And so they're not going to worry about it. They're not going to attend to it. But I can tell you, anyone above the age of 18 really should have some foundational estate plan in place. I recently helped a young family where a young father had passed away. And unfortunately, he really left something of a mess behind for his wife and minor daughters. But it really doesn't have to be the case. I've helped young people, especially young families, and I've just seen the relief that they feel from having a plan in place, that they know things are taken care of. It's not a worry that they have anymore. And if something were to happen to them, they know that the people that they love would be well cared for in that case. Maybe you feel like getting an estate plan, that's too expensive. I mean, it's got the word estate in it. It must be really expensive, right? And I am seeing some people are responding saying, yes, I think it's too expensive. I understand that. And I am cost conscious myself. And I can tell you, before word processing, before we had Microsoft Word and Google Docs and all of these different formats where we're able to create documents for people in a very efficient way, estate planning really was just for the wealthy. It wasn't for the average or the middle class folks like ourselves. But today, estate planning has become much more affordable. and really it is for everybody. It's reachable by everybody. And again, I do have some bonuses here at the end that I'm going to offer to make it even more affordable to get a great estate plan in place. And I love this. Somebody admitted to the fact that they're worried about jinxing themselves, which I really appreciate your honesty, because I've heard that from people, that they worry about that. It's like that classic scene where they just sign the wills and they walk out of the attorney's office and then they get hit by a bus or something like that, right? That I shouldn't laugh, but it's terrible. But I can assure you from my experience, I've done dozens of estate plans. And luckily, I've never seen a correlation between someone getting an estate plan done and having something happen. In fact, I always like to say, I think that my clients tend to live more intentionally and get more enjoyment out of their lives. And they pick their heads up because they don't have that weight sitting on their shoulders, worrying about what might happen when they're gone. So again, I really appreciate everybody for chiming in on the polls here today. And I've got a couple more that I'm going to offer here. So if you do have a plan in place, and I didn't see anybody saying that they did have a plan in place, actually, as many people as we have here, I was kind of surprised that nobody has a plan in place, but not everybody does. But if you do have a plan in place, or if one of the things on the screen here resonates with you, or one of the things in the poll resonates with you, I want to hear from you. Maybe you've done an online will, or maybe you've thought about doing an online will, and you want to know if that's okay and if it's going to be enough to take care of your family. And that's something that I'm going to speak to very explicitly, very clearly towards the end of the presentation here today. Sometimes a do-it-yourself will or a do-it-yourself estate plan is okay. And I'll again talk about it, and I'll talk about some things to really watch out for in times when you really want to avoid a do-it-yourself or an online will. Maybe you're wondering if your estate plan is out of date. Maybe you did it 30 years ago and your kids were minor kids at the time. And your question then is about, do I need to update it now? Is there something that has changed in the law? Is there something that's changed in my family or in my assets that's substantial enough that I really need to get this done? I really need to fix this and make sure that it's the way that I want it to be. And I'm seeing somebody saying in the chat, how outdated a plan, what is considered current? And that's a really good question. You know, there are changes in the law, there are changes in your family. An estate plan really needs to be dynamic and to flow and to be able to change with the times. And most estate planning attorneys I've seen will really try to create an estate plan that can be flexible and that can account for changes in the future. So I can tell you, even if you only have one kid, even if you have no kids, I generally write in an estate plan that, considering the fact that there might be kids in the future. And I generally write into an estate plan considering the fact that there might be grandkids or great grandkids in the future, because you just don't know if you're going to be able to get that plan updated in a timely manner in a way that you want. So there really is some planning that we can do with some foresight, but at the same time, plans do get outdated. Laws change and family dynamics change to a point where what you wanted at one point and who you wanted to oversee things at one point might not be what you want now and who you want to oversee things now. And I see somebody else putting in, how can I plan for someone who needs to be on a spend plan due to life situation? That's a great question. Can I delegate this to another family member? And that's absolutely something that we can talk about. We can tailor your estate planning documents in the way that people are able to receive assets or have those assets held for them so that they can be protected from making bad decisions with those assets. And that's something that's really important if there is a special need or a disability situation. It's something that's really important if there's a substance abuse type of situation, or if there's a bad relationship or issues with gambling. There are all kinds of situations where you need to protect somebody from the finances, from the money, the inheritance that they might end up receiving. Another question that people often bring is they want to get a better understanding of the plan that they've had written for them. And I think this is true. A lot of estate planning attorneys, when you come into their office, they'll kind of size you up and decide based on how you walk into the office and the assets that you tell them that you have, exactly what estate plan they're going to write for you. And that's not a good way to operate. If you ask me, that's not what an estate planning attorney should do. An estate planning attorney should really be educating and empowering their clients to write the estate plan that they want written. But unfortunately, that's not how all estate planning attorneys practice. And so it is the case that that sometimes people will come to me and they'll say, look, I had this estate plan written for me. I just don't really understand what it means. Can you interpret this for me? And I love to help people out with that. I love to go through and read through their documents and tell them exactly what's going to happen. And if they have concerns about it, we can adjust the plan based on their concerns. If they don't have any concerns about the way that things are laid out, then at least they have the peace and the knowledge that the plan that they had written for them is doing what they wanted to do. I see somebody putting in, what if stepsons put stepmother out of home after death of father? Oh, geez. Do we need to have will written for shares after death? And that's a really good question. My advice is to make sure that that stepmother is protected. Make sure that her right to stay in the home is protected. And there are a number of ways to do that. You can do that with something like a life estate. You can do that with something like a trust, either a testamentary trust or an inter vivos trust. And we'll talk about what both of those are here a little bit tonight, not in great detail, but we will definitely talk about those tonight. Someone else is asking, what is needed in a will? Do you need an attorney to help you write one? And that's a really fantastic question. You can write a will for yourself. And there are places that you can go where you can download an already written will and fill in your information. And that's what I'm talking about with an online will or a do-it-yourself will. And so there are some legal requirements. You have to have 2 witnesses watch you sign and sign with you. I'm trying to think. I think you have to have the date. There are some like very rudimentary requirements in order to create a will. It has to be written. For example, we don't have video wills or anything like that here in Minnesota. And we'll talk about when it makes sense to bring in an attorney to help you with your estate plan here tonight as well. That there are certain factors and certain things that you are going to want to consider. And if your assets rise to a certain level, or if you have certain concerns about family or certain concerns about the way that things are going to go, then I really encourage you to have an attorney, and I'll tell you exactly when that is here in a little bit. Does a will need to be signed by all legal heirs? And no, the answer to that is the heirs do not need to sign the will, but the testators do. That's the person who's creating the will. And it just needs to be signed by the person who's creating it and whose assets and estate it's going to govern over. Another great question. These are all really good questions. And again, thank you for chiming in either to the chat, the Q&A, or to the poll here that we just had. Whatever the case is, if you have a plan in place, if you don't have a plan in place, if you have one of the questions or multiple questions that we've already talked about or that we are going to talk about here tonight, I just want you to know that you're in the right place. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you did an online or fill in the blank will, but you're just not sure if it's going to work, if it's going to take care of you, the people that you love, in the way that you want them to be taken care of. And you're in the right place if you're nervous about how much this is cost. Again, this is going to cost. I completely understand that. As a young father of 4, I completely understand being sensitive to cost. And I promise you that I'm going to address that cost component in particular, because I know that might concern you. Again, estate planning is affordable. Estate planning is for everybody. And I love working with people and helping to make sure that they can afford it so that they can get a great plan in place to protect their family for when something happens to them. The reality is, estate planning isn't about you. It's not going to enrich you. This was really something that occurred to me or that I was reminded of recently when I was updating my plan with my wife. Estate planning wasn't about us. It wasn't going to enrich us. It wasn't going to bring us extra wealth or anything like that. But that's not who we were doing it for. We were really doing it for the people that we love, to make sure that they are cared for after we're gone. And that's, I've got my three kids pictured here. Ben is now 10 years old. Elizabeth is 7, and Margaret is 5 years old. And there's one who's not pictured there. Unfortunately, I don't have a great picture of the 4 of them, alone together. But really, that's who we were planning for. We wanted to make sure that they were well cared for if anything should happen to us. If we became incapacitated, if we passed away unexpectedly, we wanted to make sure that they had the assets, that they had the people in place to take care of them, and to really make sure that they flourished and that they were able to live the best life that they could live. Your loved ones are going to know whether you lived up to your promise to take care of it, to get your affairs in order. And that's why it's so important to do that. It's too late when it's too late. That sounds like a Yogi Berra expression or something like that, but it's too late after the fact. You've got to get this done now. You've got to get it done as soon as possible, so that you can minimize the risk, so you can really eliminate the risk of not having a great plan in place for the people that you love when they need it. So here are some of the things that we're going to cover today. We're going to talk about planning for incapacity, and we're going to talk about who can make healthcare decisions for you, who can make financial decisions for you, if you can no longer make those decisions for yourself. We're also going to talk about planning for when you pass away, and that might include guardianship if you have minor children. In fact, I'm going to pop up one more poll here. If you don't mind answering this one last poll, I'd just like to find out from people, kind of a demographic question. And if there are a lot of people with young kids, then I'll make sure that we spend some time talking about guardianship. If there really aren't anybody here with young kids, then we'll spend a little bit less time with it. But please go ahead and answer that poll when you get a chance. We're going to talk tonight about probate, and we're going to talk especially about the time, cost, and public nature of probate. We're going to talk about estate taxes tonight. We'll talk about unclaimed property, and we'll talk about intangible assets and how you can transfer your intangible assets to the people that you love as well. But before we jump into the meat and potatoes, I want to tell you just a little bit more about me and a little bit more about my family. And this on the screen here, this is my family. We live in Bloomington, Minnesota. My wife's name is Tobin, and my kids, again, are Ben, Elizabeth, Margaret, and our new baby, Bridget. And I was able to get a picture in here of Bridget, probably a little bit difficult to see in Tobin's arms there, but Ben is 10, Elizabeth is 7, Margaret is 5, and my family is really my whole world. I am really devoted to them, and I spend a lot of time with them. Love them. I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day, my first child, Ben, was born. So it's been 10 years. It's my 10-year reunion coming up. And you can see me there holding Ben for one of the very first times on the day of his birth. After law school, I found a job with a small estate planning and tax preparation law firm in Minneapolis. And I loved the clients that I was able to work with. But at the same time, I didn't always feel like I was providing the value that my clients deserved. And so after a little more than 3 years, I ended up leaving the law firm. And this is actually a picture from my last day there at the firm. Someone has to graduate at the bottom of the class. I just have to start by saying this was not said about me, to my knowledge. That was not where I heard this. But this is something that my parents said about an extremely negative experience that they had working with an estate planning attorney who helped my grandmother to plan her estate. And in particular, I remember my mom saying this: someone has to graduate at the bottom of the class. And there was a big reason for that frustration. I don't actually think it was the attorney's knowledge about estate planning, but I think it was the model that this attorney was practicing under. I'll talk more about that faulty model. I call it planning for death a little bit later. But first, let's talk about some of these aspects of estate planning. And again, thank you for chiming in on the poll here. I am seeing a number of people with young kids, and so I will share some information about guardianship, but I'll try and keep it brief for people who do not have young kids. So let's start talking about short-term guardianship. In short-term guardianship, the way that you should think about it is what happens if you leave your kids home with a babysitter you don't have a plan in place, and for whatever reason, you're not able to get home. Maybe you're in an accident, maybe who knows what happens, but you're not able to get home and get back to those kids. Well, eventually that babysitter is going to call the police, and the police are going to come to the house. And without a plan in place, without it being clear and legally documented who can be there and take care of the kids, the police are going to eventually call in Child Protective Services to get involved. And your kids are probably going to go and have to live and be with Child Protective Services for a time. And this is not to say Child Protective Services, I think, has a very difficult job. This is not to cast aspersions on them at all, but I can tell you, I don't want my 4 kids to ever have to spend any time with Child Protective Services. And that's why it's so important to get short-term guardianship documents in place, documents that are legally effective, make it very clear who can stay with the kids, and also communicate to the babysitter how to get those short-term guardians to the house if something should happen, that those are the first people that should be called if my wife and I don't get back to the house. You don't call the police right away. Obviously, if there's an emergency, you call the police. But if my wife and I just aren't showing up and you're not sure what to do, you call our short-term guardians. They're live within 30 minutes away, and they can come and stay with the kids and make sure that the kids are taken care of while the police figure out what has happened to my wife and I. Long-term guardianship, on the other hand, is who is going to take care of your kids until the age of 18. And if there isn't a plan in place, well, there is a plan out there. And the plan is that a judge is going to decide who is going to take care of the kids. And unfortunately, a lot of times that's a plan that you're not going to like. It's a plan that you're not going to be happy with the consequences from. I always say, you've got to have a plan in place to make sure that Uncle Larry doesn't end up with the kids, right? Because Uncle Larry might look great on paper. He might have a stable job and a home and who knows what else, live in the school district and all of that. But if you know that your kids are not going to flourish with Uncle Larry, you don't want Uncle Larry taking guardianship of the kids. And that makes it extremely important that you, the parents, dictate, or that you, the parents, determine who is going to take the kids and who's going to be able to raise those kids until they're the age of 18 with the values that you want and the educational experiences and the things that you want them to experience. All right, so that's the end of talking about guardianship. Thank you for staying with me. If you don't have minor kids, now we're going to talk more about the assets, and we're going to talk about the things that you have and what happens there. So if you don't have a plan in place, or if your plan is focused on a will or revolves around a will, then the state actually has an estate plan for you. And that plan for you and for your assets is a court process called probate. And what probate is a lawsuit that you file against yourself with your own money for the benefit of your creditors. It's there to make sure that your creditors get paid after you're gone. So if you have a credit card, if you have utilities that are owed, if you have a mortgage, all of those people want to make sure that they get paid. And so they have this process called probate that your assets have to go through in order to make sure that they're getting paid. Probate is, in Minnesota, it takes a really long time to get through the probate process. Probate takes at least 6 to 12 months. That's an ideal situation. But more often, probate is taking something like 12 to 18 months in Minnesota. We'd like it to go faster, but we just can't make it go any faster. It's designed to be kind of a slow process to begin with. And with slowdowns in the court and difficulty in scheduling and that kind of thing, it's really starting to take a long time. Probate's also very costly. There are attorney's fees and executor's fees, appraisal fees and filing fees. There are creditors out there that want to get paid, and there are bond premiums. All of these things really can diminish the inheritance that you want to give to your heirs, to your kids, or whoever you want to receive that inheritance. In Minnesota, probate costs in general something like 3 to 6% of the gross value of the estate. And that's not a perfect number. It's based on this amalgamation of different costs that weigh in to the probate process. But that's generally how we estimate it. We estimate that probate is going to cost something like 3 to 6% of the gross value of your estate. And we'll actually have a moment here in just a little bit to actually calculate that. But you can imagine if all that you own is a house worth $400,000, already probate is going to cost somewhere between $12,000 and $24,000 to get through that court process just for your home. It is just a very expensive process, and it's a one-size-fits-all process, unfortunately. Again, we'll have a chance to calculate your probate here in just a minute, or what probate might cost for you in just a minute. Probate's also public. So right here, this is the will of Anna Nicole Smith. Wills are totally public. They have to be filed with the court and made public so that people can go to the court and request them, or oftentimes they can be found online now. But a will doesn't keep things private. And again, a will ensures that there has to be a probate in order to deal with your assets. If you're planning with a will, there has to be a probate. And we have this really goofy saying in estate planning: where there's a will, there's a probate. It's an unfortunate saying, but it's true. A will has to be submitted to the court and interpreted by the court in order to carry out the instructions that are in the will. And when a will enters probate, it puts all of the creditors out there on notice that your loved ones will be receiving money, because the people who are receiving distributions are listed. Your assets are also listed with the probate court in something separate called an inventory, and sometimes in something called a final accounting as well. All that information is made public. If your kids are under the age of 18 and something happens to you and you don't have a plan in place, then they are entitled to receive your assets at the age of 18 and completely unprotected. And many of us know stories of people receiving an inheritance or receiving a lot of money at too young of an age, and how it can spoil their financial sense and really make it difficult for them to live a fruitful life in the future. Okay, so let's calculate your probate estate. And here I have an example probate. This might look very generous to you. It might look like this person has a ton of assets. It might look like this person has very little. We're all coming to this from different walks of life, but this is just a sample, right? You can fill in with your own information. And here I have things like the family home, a rental property, furniture and household goods, automobiles, stocks and bonds and bank accounts, and a business interest as well. That's about $100,000. And all of that totals up to $850,000. And you can get 5% of that number very quickly by moving the comma over one place and then dividing that number in half. So you divide 85,000 in half. That's how you get 42,500. So you can do the numbers yourself. If you own your home, you can figure out what 5% of that number is really quickly. Here the number is 300,000, the fair market value of the family home. You move the comma over one place, divide it in half. You can see already just having the family home, the fair market value of the family home at 300,000, you can already expect probate costs around $15,000. It's an imperfect number, but it gives you an idea of what you can expect. Just to complicate things a little bit, the thing about a family home, rental property, furniture and household goods, automobiles, stocks, bonds, and bank accounts, and business interests is that they generally don't have beneficiary designations on them. However, life insurance and retirement accounts often will have beneficiaries listed on them, okay? And because of that, they can avoid the probate process. If something passes by beneficiary designation, it does not have to go through the probate process, unless that beneficiary is a minor or a ward of the state, or somebody who just can't receive that money. In that case, if it's payable to a minor, then all of a sudden that asset, that thing that's payable to that minor becomes a part of the probate estate. And you can see if you have a life insurance policy and a retirement account that's payable to a minor, how that really balloons the cost of probate, because now you have to do a conservatorship. Somebody has to oversee and take care of those funds for that minor child until they're 18 and until they can take care of it themselves. At which point, unfortunately, they also get everything, which is not what we want to have happen. However, good news here, there is a foolproof way to avoid probate. And that foolproof way of avoiding probate is by fully funding a living trust. And so a living trust is like an instruction manual that you are writing to somebody. You are taking your property and you're giving it to someone else, or yourself in this case, but you're taking the property as a person writing this agreement, this living trust agreement, and you're giving it to somebody who is promising to follow the rules, follow the instructions that you are writing into your trust agreement, okay? And you're writing it down so that everything is very clear. But that's essentially what a trust is. And it's something that generally is written for you by an estate planning attorney with your guidance and with your input into making sure that it's taking care of the assets in the way that you want them taken care of. But a key element of making sure that a trust works is fully funding that trust. And that means different things for different types of assets. So if you have investment accounts, if you have things like mutual funds and stocks and bonds invested at some financial institution, you need to retitle those investment accounts in the name of the trust to get them into the trust. You need to go to the bank and sign new signature cards at the bank so that those bank accounts are in the name of the trust. You need to execute deeds to real property, and that's where working with an estate planning attorney can be very helpful because I take care of that for my clients. I make sure that those deeds are executed and recorded properly. Transferring stock and bond certificates, you transfer those into the name of the trust. You assign personal property into the trust. That's another thing that I really help my clients with and make sure that they get done at the signing meeting. And then changing life insurance and retirement account beneficiary designations. And this might sound like a lot, but I can tell you, I guide my clients through every single one of these steps, and I break it down for every item that they have, for every life insurance policy that they have, for every retirement account that they have. I break it down for them and say, this is exactly what you need to do in order to make sure that this gets into the trust and that the trust provisions are what dictates what happens with this asset. I make it really simple for you, but that is the way to avoid the time, the cost, the public nature of probate is by getting all of your assets into a living trust. Okay, there are probably going to be questions about that. I imagine that there are going to be questions about that because it is a big thing to consider. You can avoid probate, but you have to have a living trust written and you have to fully fund that living trust. And that's really where I am able to step in and help out. I want to talk now about estate taxes. And estate taxes are a place where I get to give almost everybody in attendance here today some really good news because there are exemption amounts under which you pay nothing in estate taxes. And the federal estate tax is steep. The tax rate on the federal level is up to 40% on the dollar for everything that is above the exemption amount. However, the good news is the exemption amount is $12.06 million, and you actually get to double that number if you're married. And there are quite a few people here who are married and would get to double that. Sorry, I got distracted. Somebody had their hand up there for a second, and I just missed it. If somebody has a question, please feel free to put it either in the Q&A or in the chat, or go ahead and raise your hand if it's a question that you want to ask out loud. So really good level on the really good news on the federal level. Almost nobody ends up owing estate taxes. It's only the very wealthy who end up owing estate taxes. On the Minnesota level, we also have an estate tax here in Minnesota. And that estate tax starts at about 13% and goes up to 16%. But the estate tax only applies to assets in excess of $3 million. Until you get to that $3 million figure, there is no estate tax collected by the state of Minnesota. And so here you can see this is a pretty substantial estate, and there would be a large part of this estate would be subject to the Minnesota estate tax. Something like $2.2 million would be subject to the Minnesota estate tax, and what the state would collect would be over $250,000. So a pretty substantial amount. Not a lot in the context of how much is in that actual estate, but it's something to consider and something to be aware of if you have assets that are approaching that $3 million mark. Will your assets be lost to the state? And this is something that many people don't know, but it is something that is very important. And I think it's even more important as if you don't have a ton of assets and you want to make sure that everything that you have is going to the people that you want to receive it. So any idea how much money is currently in our State Department of unclaimed property? And the answer to that is right now there's over $700 million in the Minnesota Department of Unclaimed Property. And across the United States, that number is something like $58 billion, billion with a B. It is a ton of money out there, and it's not doing anybody any good. But what happens is that somebody passes away and they stop interacting with their bank account, and their heirs aren't aware of everywhere that they kept their bank accounts. They aren't aware of every piece of stock that they owned or every share of stock that they owned. And so something gets missed. The heirs aren't able to collect everything when that person passes away. And instead of going to the heirs and doing them good as an inheritance and enriching their lives, it ends up going to the Minnesota Department of Unclaimed Property, where it just doesn't really get to do anything for anybody. And so this is something to really keep in mind. It's something that I address with my clients by creating an inventory of all of their assets, so that when something happens to one of my clients, I'm able to bring the beneficiaries in, bring the heirs in, sit down with them and say, all right, mom and dad had this, or uncle had this, or whoever it is, your friend had these assets, and now we can make sure that we collect everything and that everything goes to the people that my clients wanted those assets to go to. I do see a question here. What does the state do with the state taxes paid? How is the money utilized by Minnesota? And my understanding is that it goes into the general treasury fund and is used to pay for general expenses in Minnesota. I'm not aware that it's used for any specific purpose. My understanding is that it just goes into the general fund and then is used for whatever priorities our legislature decides are priorities. That's a good question. It's something I might need to look into a little bit more. Okay, this is really cool. You can make your living trust a real treasure chest with that real type of protection, lock it up so that only your heirs, only the people that you want to receive that money, that inheritance, are able to receive it. Asset protection is what I'm talking about. And asset protection means that you can protect someone's inheritance from things like a spouse in a divorce, or protect it from something like a creditor in a bankruptcy, from something like a car accident or a lawsuit at some point in the future. It is really cool. And you can build this over an inheritance in a way that they can't protect their own assets. It's just not possible to do as a first person, but because you're giving it to them in their inheritance, you can build in this airtight asset protection for them in the money that you're leaving to them. And again, it's something that they can't give themselves, but you are able to gift to them. So this is something that is very real to a lot of people. It's something that's on the mind of a lot of people right now, and that's incapacity. And that's who can make healthcare decisions for you, and what kind of healthcare decisions can people make for me if I can't make those decisions for myself. So the person pictured here, this is Terry Schiavo, and Terry was really a household name back in the middle 2000s. Terry had suffered a cardiac event, and that caused her to be in a vegetative state. And while Terry was in that vegetative state for years, her husband and her parents started to argue about what should happen to Terry. Terry's husband thought that she wouldn't want to be kept alive in this vegetative state. Terry's parents thought that Terry was still able to have some interaction with her surroundings and with the people in her world, and that she would want to be kept alive in this vegetative state as long as she was still able to exhibit the behaviors of interaction that they were seeing in Terry. So there was a big fight. There was a lot of court for the family, and it even went all the way up to the Supreme Court, fighting over this issue of Terry's life. And unfortunately, it was just a bad situation with a lot of conflict. It created a lot of conflict across the nation because it became such a high profile case. But you can tell everybody what you want from your healthcare. You can put that into something called a healthcare directive and or a living will, and you can tell everybody exactly what you would want to have happen if you were in Terry's shoes. If you were in a vegetative state and it wasn't clear that you were interacting with your surroundings, but you definitely weren't able to decide or speak for yourself, what would you want to have happen? Uh, this is a process that I go through with my clients where we talk about different scenarios and we set it down in ink and we set it down in writing so that it's very clear to the people that you love when they're in this terrible situation and they're grieving you and they're really struggling to figure out what the best action is to take. It is a huge relief to them to have your wishes written out for them so that they can read them and just execute on them without having to second guess what they're doing and second guess whether or not what they're doing is really what you would wanted to have had happen. Okay, so we've talked about a lot of things today. We've talked about probate, we've talked about guardianship, we've talked about incapacity, we just talked about who can make healthcare decisions for you if you can't make them for yourself. We've talked about the Minnesota Department of Unclaimed Property and how they can end up with your money that you would rather have going to your heirs. We talked about asset protection and how you can build asset protection into your estate plan to make sure that your heirs have that inheritance protected from things like a divorcing spouse or like something like a lawsuit against them. So you're probably asking yourself right now, what can you do today to do the right thing for your family, and what should it cost to plan right? And if something that I've talked about today has really resonated with you, if something that I've talked about, you say, yes, I do need to take care of that, I need to get that done, then really your options boil down to two things. You can either try to do it yourself and do this plan yourself, or you can work with a lawyer. And do keep in mind that not all lawyers are the same. And I'm going to talk about that in just a minute, how to get a good lawyer who's going to take care of you and really make sure that you are brought along in the process and that you understand the plan that you are writing together. So how do you choose? Would you benefit from working with an attorney, or is this something that you can do yourself? And I would say that if you own more than just your personal belongings, if you own more than things like your cars, your clothing, your jewelry, your furnishings, things like your furniture in your house, if you own more than that, then I would say that you would benefit from working with a lawyer. If you own a house, if you own substantial bank accounts or retirement accounts, or if you have a life insurance policy, that's getting into the level where you're going to want to think about working with an attorney to make sure that everything is going to work the way that you want it to work. And if you want to ensure that the people that you love stay out of court and out of conflict and have someone to turn to when something happens to you, then you really have to work with a lawyer. You have to find a lawyer who can help you and take care of you and make sure that they are there when something happens to you for your family. If you want a kids protection plan, which includes that long-term guardianship, who can raise your kids until the age of 18, as well as short-term guardianship, which is who can be immediately available to stay with the kids, and you can legally document that so they can stay with the kids. Or if you want to avoid probate or estate taxes, or if you want to protect your children's inheritance with that asset protection, then you have to work with a lawyer. Those are things that you just can't do on your own. There just aren't the tools aren't out there in order to do these things on your own. If you want to guarantee that your plan is going to work when your family needs it to work, then you really have to work with an attorney. And one story that I always tell here about do-it-yourself projects and how they can go wrong. I had a do-it-yourself project that went wrong. And it was a couple of years ago, and I was getting the fishing rods and reels ready to go fishing with my son. And we were going to go out. It was going to be, early in the morning, early for him. It was like 6 a.m. or something like that, that we were going to go to a local lake and we were going to go fishing. And I had gotten a new rod and reel for him and for myself. But the rod and reel had come without any fishing line on it. So I needed to put the fishing line on. No big deal. Ordered the fishing line. and I put it on the way that I thought it was supposed to go, and wound it up, had it what I thought was all set. But as soon as I went to actually cut the fishing line, the excess fishing line off, so that we were ready to go, all of a sudden, I don't know what I screwed up, but all of a sudden the fishing line just started jumping off of the reel, and there was fishing line everywhere, and it was a total mess, right? So I had decided to do this myself. I had decided to take it on my own and put the fishing line on, and I ended up with this mess of tangled fishing line. So what, right? I mean, it was maybe 30 cents worth of fishing line, something like that. Not a big deal. I made a mistake, but it didn't have a huge cost. There wasn't a huge risk of me making a mistake. I mean, if you know me, and you know my unfamiliarity with fishing and with doing these kinds of things, the risk was probably higher than for many of you here in attendance today. But still, you know, the risk of me goofing something up was pretty low. The cost of me goofing something up was really low. It was, like I say, like 30 cents or something like that. And I knew immediately that I had screwed something up, right? The results of my putting that fishing line on there were immediately apparent. As soon as I clipped the rest of that fishing line, I knew immediately that I had screwed something up, and I was able to take it and fix it and make sure that that everything was okay. My son and I were still able to go fishing that day, no problem. Okay, that's a great example of a do-it-yourself project that didn't end up the way that I wanted it to, but it wasn't a big deal. Estate planning just isn't that way. For one thing, you're not going to know whether you got it right or got it wrong until you're gone. And so you're really not going to ever know. It's your family that's going to know, and it's your family that's going to have to deal with the results of your do-it-yourself experiment in estate planning when you're gone. The costs of getting it wrong are astronomical, whether that's estate tax costs, whether that's probate costs, whether that's conflict in the family that could potentially tear the family apart. There is a huge cost associated with a plan that doesn't do what you want it to do. And the risk of failure is really high, I'm afraid to say. The do-it-yourself projects or the do-it-yourself wills that I've seen just have not held muster to the estate plans that attorneys can put together. And I recently, actually, I'm part of a mastermind group of estate planning attorneys, and I recently heard from those estate planning attorneys that there was another one. And when they say another one, what they were talking about, when they say another one, what they were talking about is somebody had pulled a do-it-yourself will offline, off of online, and had completed it and filled it out, and they thought that they were covered. But what they had pulled from online was a California will, and in this case, I think it was actually a California trust. California trusts, California wills aren't good here. I mean, it's not applying the law in Minnesota. These people had never lived in California, and now after one of them had passed away, one of the couple had passed away, they were looking at it and trying to figure out what they needed to do, and it was a mess, and it was going to be a mess for the family. There's a huge risk of getting things wrong. And I see somebody sharing here, Prince's estate and his family quarrels is a case in point, and it absolutely is. That's a perfect example of the way that things can go wrong. In Prince's case, unfortunately, it was a case of him not planning at all. But that's exactly right. That having no plan in place is in a way planning, and unfortunately, Prince's plan really has failed his family. I see that someone is raising their hand. I don't know if they have a question, if they want to be allowed to talk, and I don't really know how to ask that. I'm tempted to allow you to talk if you want to, and see what happens. So, all right, let's give it a try here. All right, you're muted right now, but if you want to unmute and talk, you are welcome to do so. Because I do see that you have your hand raised here. If the hand raising was accidental, you can click on the hand icon and lower it, and I'll take you off of having the ability to talk. Nope. Okay. All right. Okay. If anybody has any questions or wants to be able to talk, you are certainly welcome to just go ahead and raise your hand, and I'll look for you and give you that permission. So that's the risks of having a do-it-yourself plan. It is, again, it can work if you have a small enough estate, if there is not enough that it's a huge concern. But really, oftentimes, almost always, in fact, I would recommend that you have an attorney, at least talk to an attorney and figure out whether it would make more sense to work with an attorney. Yes. Another thing to think about is if you want to give your assets to someone other than your kids, that's the most natural way that things go, is for things to go to your kids. So if you want things to go to someone different than someone other than your kids, then you really need to work with an attorney. I see someone saying, talk about a reversible trust, and I believe that they're talking about a revocable trust. And I'm sorry that I didn't make this clear earlier, but I was talking about a revocable trust when I was talking about that living trust. And again, that living trust or the revocable trust is an agreement that you make with yourself. You're taking your property and putting it into this trust, and you're writing a trust agreement, which is really an instruction manual to the person who now holds the property, who now has control over the property. And you're telling them, this is what I want you to do with my property. That's what a trust is. That's what a revocable trust is. But by doing that, because you have the assets no longer in your personal name, you have now given them over to your trustee who has control, and you've written this document out that says exactly what they need to do and how they need to handle it. Because those assets are no longer in your personal name, you're able to avoid probate when something happens to you and you pass away. That now you have where you can avoid probate over those assets that you've given over to your trustee, that person with control. And that trust agreement not only says what the person with control needs to do, but also who the beneficiaries of your trust are going to be. And so you can really detail that, and you can detail how those beneficiaries are going to receive, if they're going to receive things outright, or if they're going to receive at ages and stages is what it's often called. You can really dictate that. So I hope that I've answered that question, but I hope that you will follow up with me if there's something else that you're hoping I would talk about and you wanted more information. I see another question. What about a house? If we have younger kids who are not on the title, and that's a fantastic question. If you have minor kids who are not on the title, I would not advise putting them on the title, because just giving that would be like giving them part of the house, and they're too young. If they're minor kids, they're too young to have ownership of the house. So what I would really recommend is, if you have minor kids, take that house and put it into a revocable trust. Again, take it, write a trust agreement, give it over to yourself as the trustee, as the person with control, and then you can write in provisions about what to do with that house. And you can write in provisions about how to give that house eventually to your kids, to your minor kids when they're no longer minors, but who can hold on to that house and who can oversee and control what happens to that house before the kids have grown up and they're no longer minors. And that's really important. Good questions. All right. So we talked a little bit about doing it yourself. We talked about online wills and what that looks like, and how, unfortunately, that's an easy thing to make mistakes on, and an easy place to run afoul of things and to have accidents happen. But I want to bring our attention back to this, because not working with attorneys is not always the same thing. And my parents had this experience working again with the estate planning attorney who helped out my grandmother, and that brought them to this feeling that someone has to graduate at the bottom of the class. And again, I don't think it was where this person graduated. Maybe it was, I don't know. But I think it was that they were planning under a bad model. They were really planning for death. And this is the typical experience that you have working with most estate planning attorneys, unfortunately. Most estate planning attorneys are going to use form documents that are just kind of set it and forget it documents. Again, they're just going to kind of size you up when you walk into the room, and they're going to write documents for you without including you in the process of designing that plan together. Most attorneys aren't going to keep money out of the Department of Unclaimed Property. It's just not something that they even consider as part of an estate planning attorney's job, which I think is a mistake. I think it has to do with how assets pass at your death. And I think it's vital to create that inventory and to have and to make sure that everything is passing to your heirs in the way that you want it to go. Typical experience might avoid probate, but maybe not. Oftentimes, it benefits the attorney if they are able to write an estate plan for you. And then when you eventually pass away, they're also able to bring your estate through the probate process because they're able to charge the fees, the attorney's fees for guiding your personal representative through that process. And that's cynical, but unfortunately, it's true. And I believe that unfortunately is true of some estate planning attorneys. Typical experience probably isn't going to keep your family out of conflict. It's just not, again, something that most estate planning attorneys are thinking about. They're thinking about things like how do we avoid taxes and you know, how can I make this as easy for myself as possible. Frankly, many of them are thinking, they're not thinking about family dynamics and keeping your family out of conflict and away from fighting with each other, which is really unfortunate. Typical experience is only going to focus on money. It's not going to focus on your intangible assets, things like your stories and your values. Typical experience leaves assets to heirs unprotected without that asset protection. It's just not something that most estate planning attorneys even know to build into their plans. Typical experience isn't going to provide ongoing legal guidance. And a big reason for that is because they're going to charge hourly fees for any future needs. Anytime you pick up the phone and ask a simple question of that attorney about your estate plan, they're going to start the clock running and you're going to get a bill in the mail 2 weeks later for their answer to your simple question. And the typical experience isn't going to adequately protect kids. You might get that long-term guardianship, but most estate planning attorneys will not do short-term guardianship nominations. You're really going to be left with this question: is my plan going to work when I need it to work? And I don't think that's a question that you should have after you've worked with an estate planning attorney. I do see that there's a specific question in the chat, and I will get to that. I will make sure to answer that here before the end, but please hold on to it for just a minute if you would. Planning with me is totally different. It's a completely different experience than that typical experience of working with a typical estate planning attorney. Because working with me, I charge flat fees and I let you choose the fee based on what you think is right for your family. And that doesn't mean that you know, I operate on donations or anything like that, but I have different fee packages that I offer, and you can choose the fee package that most closely meets what you believe your family's needs are and what your financial needs are. And I'll encourage you to do that. I'll encourage you to choose the plan that fits you the best. Planning with me means keeping your money out of the hands of the state. I'm really passionate about that the Department of Unclaimed Property, the State Department of Unclaimed Property should not be able to, or should not be the recipient of your money. Your heirs should be the recipient of your money. And that's why we keep that inventory, and we keep that inventory updated throughout our relationship as attorney and client. Working with me means protecting your kids totally, both in the immediate and in the long term. It means keeping your family out of court and conflict, because really at my heart, what I love about this job is that I am able to be a peacemaker for families. I've seen families torn apart by somebody passing away, and it breaks my heart when I see it happen. But I am a peacemaker, and I don't want to see that happen. I want to understand your family dynamics, and I want to help you to build a plan to the greatest extent possible, avoid conflict, and keep your family out of court. Working with me means that you're going to know that you made the right decisions, because you're going to be the one making the decisions with education and empowerment from me. I'm going to help and guide you along the way in exactly how to make those right decisions. Working with me means that you can protect the family money from outsiders. I can build in that asset protection for your heirs and for the people that you love, so that it can be protected from things like a divorcing spouse or a creditor. Working with me means that you're going to have a lifetime of guidance and protection, because again, it's a flat fee. If there are changes that need to happen to your plan in the future, we might have to work together. We might have to agree on some reasonable fee for making changes in your actual documents to update them, you know, based on changes in your life and in your assets. And I don't know exactly what that's going to look like. You don't know exactly what your future is going to look like. But I can promise you that, you know, we're going to have continuing meetings together where we review what we've done and where things stand. And there's not going to be there's not going to be charges for that. There's not going to be charges for phone calls or for answers to emails. It's just, you've got to have the guidance. You've got to be able to come to me when your first grandchild is born and say, you know, great news, TJ, I just had my first grandchild born, or I just had my first great grandchild born. I just want to make sure that they're accounted for in my estate plan. Can you tell me what's going to happen for my grandchild if they end up receiving? And I'm happy to tell you that. I'm happy to give you that guidance because you need to have that peace of mind around that. Working with me means that your plan is going to work when your family needs it to work. It's really a gift for the people that you love the most. It's a way of taking care of them. And now I'm gonna talk about exactly what you should expect to pay for an estate plan working with an attorney. And so planning, if all that you have is a house worth $400,000, and I recognize that's a pretty nice house. It is not as nice a house as it was, 5 years ago because of the way that the real estate market is going right now. But if all that you have is a house worth $400,000, you're going to be saving at least $12,000 if you get an estate plan in place to avoid probate. And if you have assets over $3 million, this plan is going to save your family at least 13 cents on a dollar for every dollar in excess of $3 million. I can tell you a typical estate plan with a typical estate planning attorney is going to cost $1,500 minimum, and that's really gone up recently with the way that things are going right now. But you can be almost guaranteed that it's not going to keep your family out of court and conflict. It's not going to ensure your assets aren't lost to the State Department of Unclaimed Property, and it's only going to cover your money. It's not going to cover your kids' immediate care, nor your values, assets, stories, and experience, those most valuable intangible assets that are the most often lost assets. The alternative is you can plan with me. I'm a personal family lawyer. I'm very relational. I love working with people and helping them. You can learn specifically what your family needs. You can choose your own fee, likely to range somewhere between $2,000 and $8,000, and know that your plan is going to work when your family needs it to work. And I want to make this really easy for you. I want to make this so easy. I want to give you the family wealth planning session free. And what the family wealth planning session is, it's a 2-hour-long session together, and we can do it completely virtually. But we will get together and we will talk about everything. We'll talk about your family. We'll talk about your assets. We'll talk about if you have an estate plan in place already, if you've already written a will, or if you've already written a trust or something. We'll talk about exactly what that will or what that trust means for your family and what that actually looks like. And if you don't have an estate plan in place, we'll talk about what the state's estate plan for you looks like and what it means for you and what it means for your family. Give me just a second here. I want to post in the chat so that everybody can see this, the link to my calendar, and that is my calendar. It's live. And so you'll be able to see what times I have available on there to book that family wealth planning session with me. But we'll talk in that family wealth planning session, and you'll get a lot of clarity about exactly what's going to happen to your family and exactly what you can do to change that plan and to make sure that your family is well cared for. If you decide that you want to work with me, it's a no obligation, it's a no commitment family wealth planning session or consultation with me. But if you decide to work with me, I also want to give you $250 towards the estate planning package of your choice that I offer. And I want to give that $250 to you as long as you book your family wealth planning session with me before the end of the week. And that doesn't mean the family wealth planning session has to be before the end of the week. In fact, if you look at my calendar, the only times that I have available are in June, July, August, and in the future. I don't have any times left in May because I only work with a select number of clients each month in order to make sure that I'm giving the attention and the care to each of my clients that I know that they deserve. But if you will go on and look at my calendar and you'll make sure that you sign up for a family wealth planning session at some point in the future and you get it signed up before the end of the week, and what I really mean by that is the end of the day on Saturday, I am very happy to give you that $250 towards the plan of your choice and to help you keep the momentum going so that you can get a great estate plan in place. You can get your affairs in order for the people that you love. So next steps, take a look at my calendar, click through that link, visit the QR code that's on the screen, type that URL into your browser, whatever you need to do, but go and take a look at my calendar and find a time that you can meet with me for that family wealth planning session. Again, it's completely free. It has a value of $750 because it's 2 hours of my time where we meet together, and I'm completely devoted to you. I have a little bit of prep work that I do ahead of time, and that's why it's valued at $750, but it's something that I want to give you for free so that you have the clarity, so that you are educated and that you feel empowered to make decisions about your future and about your family's future. I also want to give you that $250 towards the plan of your choice. But again, you've got to sign up before the end of the day on Saturday in order to get that. Now, I know, thank you if you've been holding on, if you've submitted these questions, and I'm sorry for keeping you waiting. I do want to answer the questions, and I'm going to do that right now while everybody is able to look at my calendar and find a time that works for them so that they can meet with me, and we can make sure that we get their affairs in order and their families taken care of. One question that I'm seeing here is my boyfriend named me as a beneficiary on the house car, but he passed away before he signed TOD on the form for the car. Oh, I'm sorry that you lost him. He assigned the house in the trust, but he wrote the name of the car in the distribution property to me. What should I do? That's a really complicated question. That's a really difficult question. Generally, titled property does not go by the personal property distribution in something like a will or a trust. If the car was in the trust, it might be a different matter. But my hope is that you'll reach out to me and we can take a look at that and we can dissect that that question in a little bit more detail. It is what I'm hearing is that the house was in the trust. The house listed you as the trust listed you as a beneficiary. And so to me, that's a very clear path for that house to take. But for the car, if the car was still in his personal name, even if he listed it as a personal property distribution, if he listed it as a specific distribution to you, then you might be entitled to receive the car. But it's just something that I would need to have a little bit more detail about, something that we would have to look at together and discuss together. Something that honestly I might have to do a little bit of research on because it's a very specific, very specific question, a very specific issue that you're having. But I hope that you'll reach out to me because I'd love to help you get an answer to that question and get some clarity to that question. Somebody else is asking, can we write a revocable trust ourselves? And that's a really good question. It is possible to write a revocable trust yourself. And again, there are DIY revocable trusts that are available online, there are options to do that. Unfortunately, I've seen it go really wrong. And I told you that story earlier about the California estate planning documents being used here in Minnesota, and the fact that the law in California is very different from the law in Minnesota. But those are the types of issues that we often see with DIY estate plans and DIY revocable trusts, is that oftentimes the wrong state's documents will be used, or there will be provisions in there that the DIYer thought meant one thing, but really didn't. It really meant something completely different. And unfortunately, it defeats their purpose when they included that provision or excluded a provision. It can go both ways, but it is very difficult. It's very difficult to draft any estate planning documents on your own, but especially a revocable trust is really a document that requires a lot of care and attention. And there are a lot of situations that you need to contemplate in the future to make sure that you've got everything in order correctly. I have here maybe a terrible question, but what happens if something happens to the attorney who prepared your trust? Yeah, that's a very good question. Is it retrievable through the state to be followed through by another legal counsel if something should happen to me? That's a fantastic question, intimidating question. And I can tell you this, the person who drafts your trust or the documents that I draft are readable by any estate planning attorney in Minnesota. Any estate planning attorney can take a look at the documents that I've drafted, interpret them, and understand what we were trying to do together, and make sure that that happens. So that's the short answer: is if something happens to me, there are other attorneys out there who can take care of you and make sure that you're able to get the treatment that you deserve, and that you wanted under your trust. Another answer that I have to that question is that I actually have an agreement with another attorney. He happens to be in Shoreview. I happen to be here, but he's agreed to take my client files if anything happens to me, and I've agreed to take his client files if anything happens to him. And so we have this agreement so that we make sure that we have coverage for our clients, and personal coverage, so that somebody can take care of our clients if we can't be there to take care of them. Very good question. I am happy that you asked that question, but it's a little tough on your attorney here. Somebody's saying this was great and very informative. I look forward to working with you in the future. Thank you, and blessings to your family. Oh, that's very nice. Thank you so much. I really appreciate that sentiment. And I look forward to working with you as well. I will look here for more questions, and just to oh yeah, thank you for your information today. Fantastic, good. I'm happy to provide it. I'm really happy that you made the time and that you were here to educate yourself about this. A couple of questions that I often get are, what is a special needs trust, or what is a supplemental needs trust? And a special needs trust is oh, and I see, thank you for your time. I really appreciate it. Absolutely. Happy to be here. Happy to provide the information. I want people to have this information because, it shouldn't be a secret. But it's something that we all really have to take care of, because it's a reality for us that we are going to die someday, unfortunately. This was informative and a fantastic segue into getting the ball rolling. Thank you. Yeah, thank you. And another thank you. I really appreciate the sentiments here this evening, and thank you for sharing that with me. Talking about a special needs trust, supplemental needs trust. When somebody's receiving benefits from the government, there are often restrictions on the assets that they can have, and the income that they can receive. And so in order to continue qualifying for government benefits, even if they're receiving an inheritance, it often makes sense to put those assets, instead of in that person's name, in something like a special needs trust or supplemental needs trust, so that the assets can be used for things like luxuries, things like going on vacations and going to the movie theater, without disqualifying that person from government benefits and requiring them to eventually reapply after the inheritance runs out. So that's what a special needs trust is, or supplemental needs trust. What kind of estate plan would an 18-year-old need? I often hear that question. And I would always recommend that they minimally have a power of attorney and a healthcare directive. And those are two very important documents that give somebody the ability to make financial decisions if they can't make them themselves, and to make healthcare decisions, and what those healthcare decisions should be that they're making if on their behalf. I see somebody else saying thank you. Yeah, thank you again for being here and for taking the time to educate yourself. I hope that everybody has had a chance to click through that link. I see somebody saying, I enjoyed your presentation. I'm motivated to take the next step. I love that. I love hearing that motivation. That's fantastic. I'm going to go ahead and post my link again so that people can click through and see my calendar and see what it looks like. I will be sending it in an email with the link to this recording here in just a little bit as well. I just, again, I really appreciate everybody being here with me tonight. I am seeing you in June, booked and ready to start. I love it. I love that. I love that attitude. I love that motivation to get this done. It is something that you can get done, and I can make it very easy for you. I can make things very simple for the people that you love when something should happen to you. And I really hope that you'll choose to work with me so that we can get it, we can get things in order and get the people that you love taken care of. One thing that I didn't get to address tonight is nursing home care or medical assistance care. And I'm really sorry that I didn't get a lot of time to talk about that. I think the person who asked me to talk in more detail about that actually had some other questions that really came up today. It is a question that requires a lot of specifics to get into. But there are ways to plan for nursing home care and for ways to protect your assets so that your surviving spouse, if you're receiving, nursing home care, it's expensive and you can go through the assets really quickly, but there are ways to get government help early on and really protect some of the assets for your spouse and for the people that you love to receive in an inheritance. It's important to do that planning early as possible. And it's really important to reach out to an attorney if that's a concern that you have, because it's very specific. Each plan is very specifically tailored for your situation. And so I just really encourage you, if that's a concern that you have or a thought that you have, to reach out to an attorney and discuss it. Reach out to me, excuse me, and discuss it. And I'd be very happy to walk through some plan options that you have there. Okay, I'm starting to lose my voice tonight. I'm going to take a little sip of water here, and then I'm going to call it tonight. I don't see any other questions coming in, but we had some really fantastic questions tonight, and I appreciate everybody's chiming in with questions. My parents just went through what you're talking about regarding nursing home care. My father just passed away. Without an attorney's guidance, they would have lost everything. That's exactly right. That's what happens. I'm glad to hear that they got an attorney's guidance and that they were able to protect things and didn't end up losing everything. All right, the next steps. You know what the next steps are for you. And if your assets are at a level where you think that you can do a do-it-yourself plan, where you feel like you can handle it, the best of luck to you. Really, truly, I mean that. If you think that you'd benefit from working with a lawyer, and I think most people would benefit from working with a lawyer, I hope that you'll work with me. And I hope that you'll go click through the link, schedule your free family wealth planning session so that we can talk together and we can get really specific about your situation, about your family, about your assets, and about what your family can expect when something happens to you. I hope that you'll take advantage of that. I know I want to be able to talk to you. I want to be able to help you with this. And that's really your next step. So I hope that you'll reach out to me. I hope to hear from you. Again, my name is TJ Scott. I'm an estate planning attorney, and I'm the owner of the law office of Timothy J. Scott. And it's really been a pleasure to be here with you tonight and to be able to talk to you. I am going to sign off now, and I wish you all a very good evening. Take care.